Hi, I'm Emily and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, how does rental property work with probate in Connecticut? There are 3 heirs to my mother's property. One heir intends to purchase the property. The mortgage and insurance are still in my mother's name. The home is a 2-family home. The heir planning purchasing lives in one of the apartments, while the other apartment was most recently rented. Is that rental property considered income to the heirs, or does it go towards the mortgage? My sister has been paying the mortgage for a year otherwise prior to renting.
Good morning, Emily. The answer to this question depends on how the 2-family home is titled in terms of ownership and how it will pass through the estate. According to your fact pattern, the working assumption is that the real property asset was solely and exclusively titled in your mother's name without any joint survivorship rights or life estates or designated beneficiaries named in the deed. If that is the case, the property will pass through probate via the will or intestacy laws and will undergo estate administration with court oversight. That would include rental income collected on behalf of the estate to address administrative expenses such as taxes, insurance, mortgages, and the like, until the property is sold and no longer owned by the estate. If there is income in surplus after payment of estate expenses during this time, that is likely to be an estate asset that can eventually become distributed to heirs. Unless the parties come to a different understanding in a written agreement approved by the court, an heir's rental payments would likely be considered as an asset that would have to be part of the estate accounting until final disposition. In Connecticut, such an agreement between heirs is called a mutual distribution agreement, which can sometimes be used to avoid any disputes under a will, if parties object in that either they feel typical estate administration might be somehow inequitable or would cause an undue hardship. From there, a valuation of the property might be in order so that the purchasing heir is viewed as buying the estate property for a fair market value, and the estate is obtaining proper compensation instead of a discount from an inside transaction. Such a mutual distribution agreement could also contain terms whereby the parties are willing to recognize credit contributions or the conversion of what were mortgage payments into rental payments and vice versa. Your sister might also be able to make a claim for some reimbursement from the estate for making mortgage payments, which ensured that the estate did not absorb any unnecessary debt. Again, this assumes the property was solely titled in your mother's name. If there was a joint owner with rights of survivalship, then the property would pass directly to that person without the need for probate oversight and administrative expenses. If you and members of your family own a rental property that is partially owned by someone who recently passed away, or that is part of an estate and you have questions about it, please contact me today at Maya Murphy PC at 203-221-3100.
Attorney Fink is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fink at efink@mayalaw.com, and please visit mayalaw.com for more information.